it's your girl, Yadit Nakasta, and you are listening to GuildCast.
GuildCast is a weekly podcast series based on the 3 pillars of the Graphic Artists Guild: advocacy, community, and business resources. Keep listening to learn more about the Graphic Artists Guild and visit our website at www.graphicartistsguild.org.
Whenever we see copyright bills come out, you'll very often see a backlash of things like, save the internet, copyright law is going to change forever. And you've got to look at those campaigns really cynically and follow the thread, see who's originating that, because it's very often a fake grassroots organization that is funded by big tech. And you can find out by looking like, who's on the board for this organization? Well, lo and behold, it's all these people who work for big tech. This is why they're trying to, quote unquote, save the internet from those evil illustrators who actually want to be able to defend their copyrights. I mean, when you put it that way, it's ludicrous.
GuildCast is brought to you in part by Graphic Arts Today. In this week's advocacy episode, advocacy liaison Rebecca Blake talks more on the CASE Act and what graphic artists can do now to prepare when the tribunal becomes real. In Rebecca Talks, the CASE Act, what now? Hi, everyone, and welcome back to GuildCast. This week, we're having another advocacy episode, which means that we're talking with our advocacy liaison, Rebecca Blake, and she is back to talk about more on the CASE Act. So our first episode in the whole thing was about the CASE Act because it is that important for graphic artists. And this time, we're doing a follow-up to hear what's next, what we can do to prepare, and just a reminder on everything CASE Act. So we're here with Rebecca. Rebecca, take it away.
Hi there. Yes, actually, the CASE Act is the legislation we've been working on for several years. It's similar legislation's been introduced in the past, I think it's past 2 or 3 sessions of Congress. And what the CASE Act does is it sets up a copyright small claims tribunal so that people like a lot of designers and illustrators who have whose work is being used by a copyright infringer, but the possible value of any recovery they would get from that infringement is pretty low, just in a few thousands maybe, that they'll have a venue where they can bring a copyright infringement claim without having to go to federal court, because before the CASE Act, the only place you could take a copyright infringer was to federal court, and the legal costs were really super high. Right. So a lot of designers and illustrators found out that they couldn't even find a lawyer who would take the case, because the legal fees to bring the case would be so much greater than any possible award they would get for that copyright infringement. And a lot of copyright infringers seem to know that. And we were hearing back from Guild members that they were seeing their work being used left and right by people who were just taking it and using it. They were using it on their websites or making T-shirts out of their artwork or whatever. And when they would contact that person and say, hey, you're infringing my copyright, the person would just say, well, so sue me. Because they knew that, the graphic artists didn't have the tens of thousands of dollars they would need to pursue this little copyright infringement case. And so what this does, it sort of fills in that gap. It sets up a tribunal, and it's a voluntary tribunal. You can always go to federal court. And but you can elect to use the tribunal instead, and they hear these really, really simple, small copyright cases, and the amount that you can recover from it is really limited. But at the same time, you don't have to invest in doing this huge amount of discovery and having to go through all these hoops to bring the case to be adjudicated. Right. So that's why we were supporting the CASE Act.
I mean, it's also interesting to think about even the fact that even when you are a creator with a big pocket, sometimes you can still lose cases based on certain things that we just don't have any control over right now. But so if anybody listening right now wants a deeper dive into what the Case Act is, feel free definitely to check out that first episode, because we went into all the details on what exactly it does and why it's beneficial for creators. And that episode, we actually recorded it some time ago. And then right when the Case Act was up in the air and the final decision was about to be made, we had that episode released. And I just wanted to go back to that with you and talk about when it happened and, you know, what exactly it means again, and, you know, when we can actually start using it.
Oh, so are you talking about the when did the bill pass?
Yes.
Okay, so the Case Act was actually, as our members know, because we sent them so many emails and,
Right.
you know, it was just constant. We're badgering them to please get in touch with your senators and ask them to support the Case Act. The Case Act had been stalled. It went through the House very quickly. It got passed almost unanimously. It was passed through committee in the Senate really quickly. It really looked like it was going to, you know, really get passed very, very smoothly. And then it got put on hold by one senator. And at that point, we just were really, really worried. Is this bill going to pass or not? So we were contacting senators and telling them that this bill is really important to us. And, you know, we hope that it comes to the floor and we hope that it's going to be considered. And what ended up happening is the bill ended up being folded into that large omnibus bill that Congress passed at the end of the year. That was the big bill that included the COVID relief package. So included in that bill were a lot of other small bills that were widely supported, that you know would accomplish things that people need, and yet for one reason or another had not been passed. And the Case Act was one of those bills. So it was folded into the omnibus bill, which was passed by Congress. And then we were all crossing our fingers because the president at that time said that he may not sign the bill because he felt the COVID relief package didn't include large enough stimulus checks. So we were holding our breaths, and then the president decided to sign the bill after all. And so at the end of December, we had a lovely Christmas gift in that the Case Act, after 15 years of efforts on the part of different creative organizations, the Case Act was passed and it was signed. So we now have a law that establishes a copyright small claims tribunal, which is fabulous.
Super fabulous. So that happened in December. So what does that mean in terms of timing? Like, when will everything actually be ready to go for graphic artists to start using the small claims tribunal?
Well, the bill built into its language some room so that the Copyright Office can actually prepare to set up this tribunal, because this small claims tribunal is going to exist within the Copyright Office. That doesn't mean people have to go to the actual Copyright Office to use the tribunal. One of the wonderful things about the Copyright Small Claims Tribunal is that all the meetings are conducted virtually, so that people around the country can bring their claims. They don't have to actually physically go into court, which is what you have to do if you go through the federal court system. But you can imagine to set this up, there is a lot of work the Copyright Office needs to do. So they have to decide, what are the rules that govern how you use this tribunal? Who are going to be the adjudicators for the tribunal? The bill calls for 3 different adjudicators to weigh in on these small copyright cases. So you've got to pick people who can do this job really effectively. There has to be a fee schedule set up. There has to be the whole process by which people can apply, and their applications to use the tribunal can be reviewed, and then they can pay their fees and in order to use the tribunal. And then the whole process of how the tribunal goes ahead has to be established. So it's a lot of work. So what the bill did is it said to Congress, you've got between 12 and 18 months to get this set up. And this is what Congress told the Copyright Office, excuse me. And God bless the Copyright Office. They are already hard at work getting this set up. But it will take some time. What they will most likely do, because this is what they have done in the past, is probably the first thing they're going to do is release some sort of an FAQs on what the Small Claims Tribunal is and how people can use it. And the next thing that they are probably going to do is they're going to issue a notice of proposed rulemaking, asking stakeholders, people who will be using this system, to weigh in on how they think the best way for the system to work will be. And if you've listened to our previous podcast, you know that one of the things that the Graphic Artists Guild does is we respond to these Copyright Office notices. So we'll respond to a notice of proposed rulemaking that the Copyright Office issues by saying, on behalf of graphic artists, we think your idea for this rule is really great, but we don't like your idea for this rule. We think that if you tweak it this way or that way, it'll be better for our creators. Very often when the Copyright Office issues a notice of proposed rulemaking, one of the first things we say is, you need to lower your fees. We want our designers and illustrators to be able to afford to use this system. So that's probably one of the next steps that the Copyright Office will do. And very often they produce other educational materials. I don't know, but I anticipate they may have a webinar on a small claims tribunal. They'll probably be issuing statements and updates. And all of this is just going to come together. Of course, they need to hire those adjudicators as well. So we're going to be watching very carefully to see when that notice comes out. And
I was just about to ask too, because you had mentioned that there are 3 different types of adjudicators. And I feel like I've heard at some point before, correct me if I'm wrong, that there is a specific type of person that they're looking for to fill each.
There's not 3 different types of adjudicators. The adjudicators are each an equal adjudicator. But the bill stipulates that the adjudicators must have knowledge of copyright law.
Right.
Which is really important.
I found that interesting too, because a lot of times in regular court, I've heard you guys talk about before, that in regular court, certain judges or persons in charge of making decisions may not understand the certain nuances that are important for graphic artists and designers or creatives in general, and may not make a decision based on those things, which is hurtful to the entire situation, right?
Yes, judges, it's very important in copyright cases that judges understand copyright law, and in federal court, you don't know if the judge in a case understands copyright law. The reason why this is important is because there are some areas in copyright which are a little bit murky. For example, if a case involves fair use, fair use is the concept that in certain conditions, under certain conditions, the use of a copyrighted work is fair. It's not infringing because that use benefits society at large for whatever reason. So, for example, one very common example of fair use is for educational purposes. Teachers need to be able to hand out photocopies of a short story, for example, to teach their students. That would be a fair use of that short story, for example. But when you have a court case, your defense lawyers, lawyers for the copyright infringer, are of course going to want to twist everything to the benefit of their client as much as they can. So they may argue that something is fair use when people who have a better understanding of fair use may say, no, that actually falls into infringement. That's not a fair use. Or they may challenge whether or not a copyright, a work has been properly registered with the Copyright Office. To go into federal court with a copyright claim, your work needs to be registered with the Copyright Office. And that registration, if you make a mistake on your copyright registration, the defense attorneys may seize upon that and say to the judge, that copyright registration should be thrown out because this mistake was made in the copyright registration.
GuildCast is a weekly podcast series based on the 3 pillars of the Graphic Artists Guild: advocacy, community, and business resources. Keep listening to learn more about the Graphic Artists Guild and visit our website at www.graphicartistsguild.org.
Very often a mistake will fall under whether or not the work was published or not. And that's because there's some uncertainty on what publication means. So if you have a judge who is not as familiar with copyright cases, they may in fact take a look at that argument by the defense attorney and decide, yes, that work wasn't registered properly, and therefore this person can't bring a copyright infringement case, and the case may be thrown out. So that's the reason why it can be really, really difficult in federal court, and why it's so important for these small copyright claims that the adjudicators understand the nuances of copyright law. By the way, you'll notice I keep saying adjudicators. I'm not saying judges. Well, there's a really important reason for that. The Copyright Small Claims Tribunal is not instead of federal court, it is in addition to federal court. And so I'm very careful not to say judges in the tribunal, because I don't want people thinking that the Small Claims Tribunal is instead of court. By our Constitution, everybody has the right to be heard in a court of law, and that right hasn't been taken away from anyone. So the tribunal is entirely voluntary. The people who are bringing a case before the tribunal are doing it voluntarily. They have a choice to either go to the tribunal or to use federal court. But the people they're bringing the action against also have the right to federal court. So the person who is being taken to the Small Claims Tribunal can opt out, can say, no, I don't want to go to the tribunal. If you want to sue me for copyright infringement, you have to go to federal court. We think a lot of people, though, are going to prefer to go to the Small Claims Tribunal because the award is so limited. If they go to federal court, they're taking a gamble that the person suing them isn't going to win, and then they're going to have to pay 10 times what they would have to pay if they'd gone to the Small Claims Tribunal.
That makes a whole lot of sense. So what I was thinking about while you were speaking was, I'm sure we can't really answer the question of what to do specifically, or how we can prepare specifically in the meantime. But what would you suggest for graphic artists that probably have a situation where they want to take somebody to the small claims court? Like, what can graphic artists or designers do in the meantime to prepare?
Well, they should be doing what graphic artists should have been doing all along, except now they have a much greater incentive to do it, and that is they have to register their copyrights. Yes. So it's really important that your work copyrights be registered so that you can use the Small Claims Tribunal. So when you create a work, it is automatically copyrighted to you as soon as you have created it, as soon as you put it in tangible form. So in other words, as soon as you make that drawing on paper, it is copyrighted to you. You are the creator and you are imbued with copyright as an automatic right upon creation. Or as soon as you write down those words in that story you're writing, or as soon as you create your digital illustration or design, it is copyrighted to you. But in the United States, you can't defend your copyrights against a copyright infringer in federal court until you have registered the copyrights. Now, with the Small Claims Tribunal, you can initiate a claim, but on a work where you haven't registered it, but you do need to register that work to use the Small Claims Tribunal. So what we tell everybody is, register your copyrights on the works as much as you can, and that can be very expensive. So what you can do to cut the costs to you is you can actually register a group of 10 works before they are published. And we recommend that people do that. But what we mean by before they are published is before you post them on social media, before you deliver them to the client with the understanding that the client is then going to start using them, before you put them on your blog, before they're published. You can register up to 10 works for one registration fee of $55. So that's the most economical way. You have to be careful if you are putting work in your portfolio. Technically, putting work up in your portfolio isn't considered published. And the reason why is because the Copyright Office makes a distinction between something that is meant for public display, like hanging a work on the wall of a gallery, that's for display, that's not published, versus something that is published. And a portfolio is generally considered something that is for display. Where you have to be careful is if you have somehow on your portfolio website made it clear that people can further distribute your work, then it's probably considered published. So if you've included in your portfolio sharing icons, then it's probably considered published instead of just for display. Now, this is a little bit of a gray area. There's no real clear guidance from the Copyright Office on this, but we're trying to think ahead on what could ever happen if you had to go to federal court. We don't want people's registrations to be thrown out because they're inaccurate. By the way, you need to be really careful if you use a portfolio service like Behance, because Behance can include those sharing icons, and you may not be aware on your sharing on that portfolio website whether or not those sharing icons are a default setting. If they're a default setting, you've authorized people to share that work. That work may then be considered published. So my advice to people, if you want to be really careful, is before you even put it up on your portfolio, see if you can register a group of 10 works in an unpublished collection. That's the most economical thing to do. Otherwise, you have to publish individual works, and those individual works, it's a single registration, and that's for $55 each. So that's really expensive, and we know that that's out of budget for a lot of designers and illustrators. So what you're probably going to have to do is just take a look at the body of work you've done and identify the pieces you think are really ripe for infringement. Maybe you've done this really cool logo that's really timely. Maybe that logo is playing off something that just recently happened in the news. And because it's just in the news, people are going to be really attracted to it, and they're going to want to share it and use it. Some jerk is going to want to take it and start selling T-shirts with it on it. Well, that would be a good thing for you to register the copyright to. Or if it's a work that you've invested a lot of time and effort into, and you really want to license that work, you want to see if you can find a publisher or somebody who does lots of giftware, for example. Maybe it's a beautiful illustration that would be beautiful on greeting cards, and it'd be beautiful on napkins, and they could make a textile design out of it. That kind of work where you really think you could license it, that would be a really good work to register for copyright, because you're going to really want to control the license on it. So because of the high cost of registration, you will have to sort of think hard about what works you want to register. But again, the affordable option is 10 works as part of an unpublished collection, so before they've been distributed anywhere.
That's really good advice. That's really good advice, because I feel like that's one of the biggest concerns, I feel, for most people that I have any kind of conversation with about anything to do with copyright. They're like, oh, it's so expensive.
It is expensive. And a really big reason why people haven't invested in registering their works is because they know that if their works are infringed, that chances are they're not going to be able to go to federal court.
Right.
So what the Small Claims Tribunal's done is it actually gives people a venue to defend their copyrights. So all these people have been disenfranchised because of the high cost of a federal court case, can now start defending their copyrights. So the time is ripe now to start registering your copyrights.
So I have a question for you, because I know that based on all of what I've seen you do personally, not personally, but what I've seen happen since I've been a part of the guild, my question for you is, could you, because I feel like sometimes creators might miss the importance, even though we have all of these conversations, they might not see specifically how it applies to them and how it helps them. Could you off the top think of any, maybe a couple case studies, quote unquote, case studies, or just situations where artists could have benefited from having their work copyrighted, or just a situation where the Case Act would help to fix a problem that creators now have?
Those are two separate questions that are thoroughly entwined. One is the question of, are there case studies where it would have been good for a copyright holder to have registered their copyrights? And the second is there a case study showing where the Case Act would have helped? And on one hand,
I'll take both. Yes.
Yeah. On one hand, they're two separate questions. On the other hand, they're pretty thoroughly entwined as well, because the power of copyright for a creator to protect the licensing ability of their work and the integrity of their work is undeniable, and it's threaded through both questions. In terms of, there are many situations where a visual artist has been hurt in the past by the fact that they did not register their copyrights. There's one case I'm thinking of in particular, and I do not want to say the illustrator's name because the illustrator has actually removed all references to this copyright infringement. And I think the illustrator did this because they were forced to because of a settlement. But there was a very well-known illustrator who discovered, to her horror, that her beautiful illustrations had been taken by a company that produced giftware. And that company had taken her illustrations and sent them off to, had outsourced them to artisans overseas who made cute little, I think it was Christmas ornaments based on her illustrations, which they were happily selling. And the company was selling these ornaments to, the company does B2B, it does not sell to the general public. So the company was selling these ornaments to places like West Elm and Urban Outfitters and all these, major retailers. And she was just, gobsmacked that her work was infringed in this way. So she went onto social media, and because she's a very well-known illustrator, she has a huge following. She went onto social media and the illustration Twitterverse kind of blew up with people spreading her story about how this company, which, by the way, has a very solid history of infringing creators' copyrights, had taken her work and was happily monetizing it. And she was furious, justifiably furious. And so she started a blog series. And in the series, she showed, this is my illustration and this is the ornament. Yeah, you could see, totally ripped off. I mean, they hadn't even changed the patterns that she had used in her illustration. And then she started detailing the story of how she was getting in touch with a lawyer and how she was doing this, that, and the other. And this actually brought to light this company's solid, sordid history of infringing the works of illustrators. So we started seeing more and more stories coming out about how this company was engaging in this. And then the San Francisco Gate ran this major article about it. So really her blog posts, there already had been a lot of reports on this company, but because she was a well-known illustrator, it really kind of blew up and put a spotlight on this company.
In this week's advocacy episode of GuildCast, Rebecca Blake, advocacy liaison for the Graphic Artists Guild, continues her conversation on the Case Act and talks the Case Act. What now?
And then she issued a blog post saying, "Bad on me. My copyright lawyer told me that I am in a really difficult position because I had never registered the copyrights to my illustrations." So
that sounds tragic.
Now, what does that mean? If she had taken this to federal court, first of all, she'd have to register the copyrights on all of her works before she could go to federal court. But because the infringement occurred before she registered the copyrights, it's not considered a timely registration. So what does that mean? If it isn't a timely registration, the court will still hear your case because you did register the copyrights. But because you hadn't registered the copyrights before the infringement, the court's going to award you actual damages and not statutory damages.
Wow.
And actual damages are very difficult to prove. Statutory damages are when the court says, you know what, this was really egregious. We're going to grant the copyright holder who was infringed this amount of money. Actual damages is you saying, I lost this actual amount of money. And for her, I mean, I'm sure she would have gotten a nice sum from licensing that illustration, but how do you prove that?
Yeah.
They're going to want to look at real, actual,
It wasn't like she had a deal in progress and there were numbers associated with it, and then
Now, what ended up happening next is she removed every single social media post on the case. She removed all of her blog posts on the case. She went mum. And what we know happens with companies like this, and this is probably what happened with her, chances are that sleazy company ended up settling with her. And the reason why they had to settle with her is because even though she couldn't take them to federal court for statutory damages, she still could take them to federal court for actual damages, and that would have been a huge embarrassment to them. Right. But the second thing is she had this huge social media following of people who on her behalf were furious. So it behooved them to come to a settlement with her. And what the copyright infringers do with these settlements is they will build in language saying, we're going to give you this amount of money to make you go away, to compensate you because we used your work. But in exchange, you have to be completely mute on this. You have to remove all your blog posts. You have to remove all your social media posts. You can never discuss this case. You can never discuss the outcome of this case. If you do that, then you owe us back the amount we settled for.
Sounds like the movies.
And this happens all the time. Now, so this was a case where if she had registered the works, she could have proceeded in federal court, and the statutory damages, because of the amount of business this company does. I mean, they sell to every major retailer. The amount of business this company does, she could have really, really taken them to task in federal court. So I really wish she had.
A quick question. Do you think that well, I guess she probably maybe just answered it. I was going to ask, what do you think if you were in her position, how would you have approached that differently? Even if you still didn't have the copyright, I'm not saying you would have not, but just to say you're her, what would you have done differently? When
she found out her work had been infringed, the only misstep she did was not registering the copyrights.
Okay.
And I can't castigate her for that. I mean, I wish every designer and illustrator registered the copyrights, but we do not have a culture in graphic arts of registering our copyrights. And I think a very big reason for that, two very big reasons, that one is the high cost of registration. You know, your average illustrator earns around $50,000 a year. You know, actually, most illustrators I know have dual incomes because they can't afford to live solely by illustration. Many of them teach as well. Many of them they'll do design work as well. So $55 a pop to register the copyrights on her work, because when she was doing this was before we had the group registration option. You know, that's a lot to ask somebody. And now she's a successful illustrator, so chances are her income level was higher just because she is gifted and she has good clients because of that. But even then, that she's in an industry where we don't have a culture of registration. The second reason why people haven't registered is because there's little incentive to register when the primary benefit of registering is that you get to go to federal court. Right. And you can't afford to go to federal court because, again, you're earning $50,000 a year and your average court case, you know, is going to be over your annual income, the cost of an average court case. So I think she did everything right. The only misstep she made, which she thoroughly owned up on, was I didn't register my copyrights. Yeah. And I can't blame her because that's true for most people. I really wish in the art schools that they would hammer home the need to register copyrights. This was
I mean, that's even a part of like business in general. Like I feel like that could be a class or a course in itself for students at any level, not any level, but at the level where they're getting to going into college or graduating from high school, even like understanding how to protect something that you've made. Like, is important and can help you in so many ways. It's like what you just said was so true.
Yeah, exactly. There are many art schools do teach business of design and illustration classes, and they do cover that. Yeah. But what I wish is that it was the idea of registering your copyright were so deep into our culture that in their different illustration classes that the illustration professors would say, you know, don't forget, you do need to register your copyrights in order to really protect it if you're putting it out there in the world. I wish it was so deep in our culture that it was, you know, it was almost like brushing your teeth, you know, it was just part of what you do.
So I wanted to also hear, because I know you have a million examples in your brain, an example of somebody registering their copyright and it working out for them.
So you're talking about situations where the Case Act would have helped. Right. We've got a number of case studies that we put together to support the Case Act. Some of those case studies actually speak to how we think the Case Act will deter infringement. So some of those case studies, somebody infringed a copyright, but it was more of a violation of a contract they had. They were using something work that they had commissioned, but they never made the final invoice. And because they never made the final invoice, they actually didn't have the rights to use that work. But that technically is a contractual dispute. However, there are other case studies where it is really clearly a copyright infringement. And the one I'm thinking of, we have one case study of an illustrator who produced beautiful illustrations that were used for a Broadway show. And he had created those illustrations and had licensed them to the company that the producers, the production company. He had licensed them to use his illustrations, and he gave them a really broad, generous license, considering how much he was paid. So they could use his artwork online, they could use it for social media posts, they could use it for posters, they could use it to create merchandising around the show, and they could also use it for the design and branding for their touring company. And that was all well and good. And the touring company went around the States, and it actually also went overseas. And, a couple years later, he was like sort of looking over his portfolio, and he said, I wonder what happened with that show, because the show had already closed on Broadway. He knew there were touring groups out. He said, I wonder if it's still being used in touring companies, just out of curiosity. And so he did a little Google search, on the show. And then he started seeing his image cropping up, not related to the touring company, but cropping up in all of these little local community theaters. These little local community theaters all around the country. And actually, I believe he found it being used in Europe as well. I think he found it being used in Italy. This was not the touring company. These were little local theaters who were producing that play and using his artwork for the posters. And he was kind of furious, like, my God, these people are just so, these people are just such thieves that they just think... And he was getting angrier and angrier, and he contacted a couple of them to say, that's my artwork. That's copyrighted to me. You don't have a license to use it. And they responded, they said, we're so sorry. We licensed the musical from the production company, and they sent us this entire package, including artwork we could use. So he then realized, oh my God, they're not the ones going and taking my artwork and use work. They're being given a package. They're paying for the right to produce this musical, and part of what they're paying for is my artwork. But he had never licensed the production company to be able to take his artwork and then relicense it. Exactly. Wow. He got in touch with them, and their first response to him was, if you take this to federal court, we will blacklist you, and you will never be able to work on Broadway again.
Don't say that. For real?
That's what they said to him.
Oh, no.
He actually ended up pursuing it. He could not find a lawyer in New York City that he could afford to take the case. So he ended up settling. He had two problems the Case Act addresses. Number one is he couldn't find legal counsel that would take the case because the award would have been so small compared to the cost, because the production company made it very clear they were going to dig in their heels. And the second thing the second thing is the production company basically, by threatening to blacklist him, said to him, "So sue me."
Right.
He ended up finding a lawyer who did negotiate a settlement with him. So he eventually was able to get the settlement, but he said the settlement amount was under the limit that he could have gotten through the Case Act, by the way. It was under the limit. So the Case Act would have helped him. He would have gotten a higher amount than the settlement. And the second thing is, he said, if I look at the hours I spent, he estimated it was over 100 hours just for him to track down how his work was infringed. Because you got to remember, he first thought it was these community theaters that were infringing the work. Yeah. So he had to keep reaching out to people to find somebody who would just answer him honestly, like, where did you get these materials? Because a lot of the community theaters were absolutely shocked when they got his email. They're scared to talk to him.
Of course.
It just took him hours and hours and hours to figure out what had happened and then to pull together all the materials. So this is a situation where he would have gotten a higher award if he'd gone through the case through a copyright small claims tribunal. I personally think that had we had a small claims tribunal in existence, that there's a very good chance the production company would not have infringed his work to begin with, because
they would have felt that
they would have known he would have had a recourse. He would have had a recourse. So I do believe, and I hope I am borne out, that the Copyright Small Claims Tribunal is going to do a lot to educate people on the fact that copyrights are owned by individual creators who are hurt by infringement. I think a lot of people grab work and use it without thinking that through.
Coming up on this episode of GuildCast.
Whenever we see copyright bills come out, you'll very often see a backlash of things like, save the internet, copyright law is going to change forever. And you've got to look at those campaigns really cynically and follow the thread, see who's originating that, because it's very often a fake grassroots organization that is funded by big tech. And you can find out by looking, like, who's on the board for this organization. Well, lo and behold, it's all these people who work for big tech. This is why they're trying to, quote unquote, save the internet from those evil illustrators who actually want to be able to defend their copyrights. I mean, when you put it that way, it's ludicrous.
Join the Graphic Artists Guild to listen to the full version of this episode at www.graphicartistsguild.org. Thanks for listening to GuildCast. Coming up in next week's episode.
One of the things that I'm learning to do, and I know sometimes it's hard for us, is to say no. And when you say no, it's not about saying no and feeling guilty and feeling bad and horrible about it, but it's knowing your boundaries, knowing that if you're saying no, it's because you're actually saying yes to other things in your life. You're opening up for other things. And that's something that we really need to think about.
GuildCast is a weekly podcast series based on the 3 pillars of the Graphic Artists Guild: advocacy, community, and business resources. Keep listening to learn more about the Graphic Artists Guild and visit our website at www.graphicartistsguild.org.